We have with us today a few speakers from UiTM and also from Indonesia, Ahmad, Dahlan University. This is the first series of seminars, webinar series, which organized by Cluster Governance and Public Policy under the CoSI, Centers of Social Innovations, under the Institute Research of Institute Sustainability Building, UTP, Universiti PETRONAS. So we are lucky today. We are so fortunate today to have these sessions that will discuss about emergency and COVID-19. It's a very current topic, very interesting topic, and it's also a topic that covers both countries, Malaysia and Indonesia. We have experience of doing this. I think Indonesia has already experienced this last year. We, Malaysia, we just have this emergency law being held in our country just recently. So I think this is the time, a good time where we can actually educate the publics, UTP students and all the listeners on what is emergency law, what is the application of it, and what is the implication of these laws to the society. It's not just to know the restrictions of it and the legal effect of it, but also actually to know how we should deal with this, how the public should deal with this, especially with this condition of pandemic, and not just to debate on the matters in the concerns of economics and politics. Of course, it is interestingly, the topic of politics also quite interesting, looking at the topic here or in the situation in Malaysia, but that is not the issues, that is not all the issues is all about. So there are many other contexts, there are many other perspectives that this seminar would inshallah enlighten us and give us more understanding, and to give us our rights and what should we how should we deal with this, and how this actually laws is actually assisting us in the hard time of a pandemic. So we have a few distinguished speakers to share with us on the topic we have with us today. The first speaker is Professor Datuk Dr. Shamrahayu Abdul Aziz. She's a Chairholder, the Institution of Malay Rulers Chair, penyandang kursi Institusi Raja-Raja Melayu, UiTM Malaysia. Thank you very much, Prof, for your willingness to share with us, to be with us today. And we also have our guest speaker from Dahlan University, Ahmad Dahlan University, Dr. Anom Wahyu Asmorojati, from the Faculty of Laws, Ahmad Dahlan University, Indonesia. He will also explain and share with us some of the situation of pandemic, as well as the emergencies law that are being held in Indonesia. And also we have our own speakers, Madam Arfah, Arfah Abdul Sapian, from the Cluster of Governance and Public Policy Center of Social Innovation, ISP UTP. So we also have with us the head of the Center of Social Innovation, Professor Dr. Sharina Nordin. And I think before we proceed of our discussion, I would like to invite Professor Dr. Sharina to give her welcoming remark for this seminar to all of the audience. Thank you very much, and I would like to invite, floor is yours, Dr. Sharina.
Okay, Bismillahirrahmanirrahim. Thank you very much to our Mr. Chairperson, Associate Professor Dr. Muhammad Nuri. Thank you, Doc. Assalamualaikum warahmatullahi wabarakatuh, and a very good afternoon to our honorable invited speakers, and also to everyone present. We have quite a number of audience today. It's, I think, almost 150, I think, more than 100. So the topic today is simply very important. It is very important and very current, very highly relevant to our situation that we are in today, which the topic is emergency and COVID-19. So as we all have gone through so many months of going through the pandemic effect, COVID-19 has caused a lot of uncertainties in our livelihood, in such a way that we had never imagined before, and to the extent that it has caused fear amongst many of us, amongst the communities, amongst the societies. And some may have even been psychologically affected by the way things are going on through this pandemic, and that we are going through this pandemic. So the pandemic has altered quite a number of ways in the way that we do things in our life. And recently, not quite recent, but more recent than Indonesia. So Malaysia has just announced that we are implementing the state of emergency. So that has had previously also caused some kind of panic. Yeah, but we need to understand what exactly it means, and what is the scope, and how would we be affected, and what would be our role in this particular situation. So that would be very important. Yeah. So we are very lucky today, as what Mr. Chairperson mentioned just now, yeah, that we have very renowned speakers. We have today with us Yang Berbahagia Datuk Professor Dr. Shamrahayu Abdul Aziz from UiTM Malaysia. She will be talking about emergency law, Dr. Nuri, emergency law and the role of Yang di-Pertuan Agong from the perspective of Malaysian Federal Constitution, which is very important because we, as the citizens, would like to know the role, and how do we match, and how do we actually play our own role as well in order for us to actually overcome and combat COVID-19 together. And then, and all the way from Indonesia, Dr. Anom Wahyu Asmorojati, welcome, Doctor, from UAD University. And Doctor will share with us on Indonesia's COVID-19 emergency law. And everybody knows here that, or most of people know actually, that Indonesia has already done that earlier than Malaysia. And we also have with us our very own Ms. Nur Arfah Abdul Sabian. She's from Center of Social Innovation CoSI, UTP, and she will be talking about the rights and duties of citizens during emergency. So this is a very important webinar to us to have ourselves educated and well prepared, on emergency state implementation, though it has already been going on for quite some time now. So we also need to be aware of the scope to avoid any misunderstanding, and how would actually the implementation affect us or help us to combat COVID-19? What should be our role? How do we play our part in this situation? Just a little bit about CoSI, Prof. Dato and also Dr. Anom. CoSI was established in 2014. The name is Center of Social Innovation, and it houses 3 clusters. Number 1 is education for social change. Second cluster is social business and social innovation, and the third one is the third cluster is governance and public policy cluster. So I am very grateful to our colleagues from the governance and public policy cluster CoSI, GPP, led by Dr. Nuri himself, to organize this very important session for our fellow colleagues at the university who are in the audience, and also for our fellow students who are also attending this session, and also some of the invited participants from outside. So thank you very much. Back to you, Mr. Chairperson, Dr. Nuri. Assalamualaikum.
Waalaikumsalam warahmatullahi taala wabarakatuh. Thank you very much, Professor Dr. Sharjina, head of CoSI, for her welcoming speech. And like what she has shared, that this is a very important webinar series. I think this is where actually, because to be frank, this is the first time that myself has encountered this experience of state of emergency. We have never used to have this. I think the last period we talked about 1970. This is where the conditions, or the tense between communism and so on. So there are military acts or conflict and so on. But in the situations whereby the pandemic has causes things that need to be controlled in such a manner. So this is something that I think all of us need to be aware. This is where we can actually educate, and we can educate, and we can give exposure to most of us. That do not really know the stand of these states in legal impact, and what is actually the things that can implicate us from this condition or this state. Okay, I think before we start with our first session, our first slot, I would like to call upon again Dr. Sharina to open the camera. And okay, Ms. Arfah sorry there, Dr. Anom, Prof Datuk ada ke? Prof Datuk, kalau boleh nak tengok gambar, kita nak ambil gambar lah, just a photo sessions, because Dr. Sharina has another meeting at 3. Am I right, Dr. Sharina? So Ms. Arfah dia nak ambil photo session lah for this, for then to include Dr. Sharina to be here.
Ustazah Mashita also join us. Ustazah Mashita.
Ustazah Mashita ada, okey. Ustazah Mashita, so you boleh siapa yang ambil gambar ni, nanti Arfah ambil gambar. Aduh, nak buat ni ya.
Apa yang ambil kejap.
Okay. 1, 2, 3.
Okay.
Arfah ambil satu. Alright.
Sekejap. Akak, kenapa dia tak jumpa, dia tak semua Macam mana nak bagi dia semua?
Di dekat galeri tu.
Galeri? Together, bukan together.
Dia tak boleh mush, large gallery tu tak boleh. Pasal apa? Dia tak tu. Tak boleh tekan yang tu.
Large gallery tak boleh.
So ada yang tu saja.
Ada yang boleh. Akak boleh tak?
Tak apa. Nanti I ambil satu gambar untuk you.
Okay.
Okay, saya ambil ni. 1, 2, 3. Hai. Sekali lagi. 1, 2, 3. Okay, nice. Okay. Okay, thank you very much. Let me share again. Okay, so for the first slot, I think we're going to have a 3 slot or 3 sessions of this webinar. The first speaker would be Professor Datuk Dr. Shamrahayu Abdul Aziz. So what we would like the Datuk to share with us is actually the topic of emergency law and the role of Yang Pertua Angola. I think this is something that we need to know the provisions of legal authority. This is something that, because I think political has always discussed a lot of this. This is politics, something like that. So this is being being spread and viral, and the discussion, I think we need to be in the know of what is actually declarations, what are the misconceptions of declarations of the emergencies, maybe why now, because Indonesia has been implemented this since in March last year. So this is some of these questions that's been asked by many, maybe that Professor Dr. can use this platform to enlighten us more of this the issues of emergencies in Malaysia. So we would like to invite Prof. Datuk. Sila. You have to unmute Prof. Datuk.
Unmute.
I do.
Okay.
I've already done.
Okay, dengar dah.
Okay. Assalamualaikum warahmatullahi wabarakatuh. Alhamdulillahirabbil alamin. Wassalatu wassalamu ala asyrafil anbiya'i wal mursalin wa ala alihi wa ashabihi ajma'in. Thank you very much for the organizing committee and also the organizer, Universiti, Teknologi, PETRONAS, and my beloved sister, Ms. Nur Arfah. I would like to thank also the head of the Center of Social Innovation, Dr. Nuri, as the moderator for this afternoon. And I'm thankful, I'm humbled to be invited to speak at this important event. Yeah, I'm thankful also to Dr. Sharina for giving me the opportunity to be here and share my views on the topic of state of emergency and the role of the Yang di-Pertuan Agong in the Federal Constitution, a Malaysian experience. I would like to send my salam kenal kepada Profesor Maria Dr. Anom Wayu Azmarojati. Welcome. then I probably have no experience yet with Dr. Anom. Then I would like to learn from you also, Doctor, for the state of emergency and the Indonesian experience, inshallah. And my topic, may I know how long is my presentation time?
It's supposed to be 30 minutes, but of course we can consider.
30 minutes or 30,
30,
30?
30, Prof.
Yeah, that is long enough for me. That's okay. I have prepared not a comprehensive PowerPoint, but it's just a brief outline of what I'm going to speak, because I always say I don't believe in the power of the points, but I do believe in the power of the words. So the things that I'm going to share here with all the participants, now we have almost more than 200 people or participants watching us and together with us to learn and also to participate, to share views on the role of the Yang di-Pertuan Agong in the Federal Constitution regarding the state of emergency. Before I go to the details of the role of the Yang di-Pertuan Agong in the Federal Constitution regarding emergency, I think it will be useful for us to know who the Yang di-Pertuan Agong is. As the name suggests, the word Agong means supreme, or the word Agong means Lord. Yeah, if the Yang di-Pertuan Agong in simple translation to the English phrase or in English terminology is that the one who is made Lord. So is the highest, is the head of the state, is the highest position of the country, as we have in the Constitution, Federal Constitution, Article 32 says that the Yang di-Pertuan Agong is the supreme head of the Federation. How is it related that his supreme head of the Federation and the state of emergency, or the law regarding emergency, or the proclamation of emergency? I will explore this in my presentation. Yeah, let's go to the second slide. And I mentioned in the second slide that do I control the slide? Yeah. The second slide, I explained that it's just a brief, as I said, it's just a very brief note. The general understanding or the general position of the Yang di-Pertuan Agong in the Federal Constitution. As I said, in Article 32 of the Federal Constitution, it says that the Yang di-Pertuan Agong is the supreme head of the Federation and is the head of the states. As we Malaysia practicing constitutional monarchy, we are one out of 44 countries in the world that having constitutional monarchy, and we are one from out of 11 countries in the world, Muslim countries in the world having constitutional monarchy, and there are only 29 monarch in the world that we are out. We have there are 29, but we have 10 in Malaysia. I mean, we have 9 in Malaysia. Malaysia has 10 thrones of rulers, but we have 9 Malay rulers. So it is to note that we are living in a country which has which is practicing the constitutional monarchy. And our constitutional head is the Yang di-Pertuan Agong. And Yang di-Pertuan Agong at the federal level has powers regarding executive, legislative, and judiciary. The executive powers includes powers to appoint important positions like the Attorney General, the Auditor General of the country. Yeah? And what we are talking about today is about proclamation of emergency and power to legislate during emergency. It is to note that the Yang di-Pertuan Agong proclaims emergency, whether it's a question of whether the proclamation of emergency is an exercise of the executive powers or is it an exercise of discretionary powers. These are the things that we are going to discuss, or I will share my views on the subject. Okay, now people are talking worldwide. We are talking about constitutional monarchy. When we say constitutional monarchy, it means many people understand it as monarchy acting on their advice. So our constitution, or the federal constitution, provides very clearly that the Yang di-Pertuan Agong whether he's acting on the advice or he's acting on his prerogative when His Majesty proclaimed emergency. That is the issue that I want to bring here. Generally, it's understood that the Yang di-Pertuan Agong shall act on advice. We have Article 40, Clause 1 and Article 40, Clause 1, capital A, which have been included in the Constitution in 1994 to emphasize that the Yang di-Pertuan Agong shall act on their advice. Although it was we had it in Article 40, Clause 1 before 40, Clause 1, capital A was inserted in the Constitution. At the same time, though we have provisions on constitutional monarchy who's acting on the advice, at the same time we have in Article 40, Clause 2 of the Federal Constitution that the Yang di-Pertuan Agong does has some discretionary powers, or what people claim as prerogative powers, meaning the powers that the Yang di-Pertuan Agong exercises without the advice or without seeking advice or without acting on the advice of any party or any members of parliament or any members of the cabinet. So there are a few matters that mentioned under Article 40, Clause 2 regarding powers of the Yang di-Pertuan Agong. One is appointment of Prime Minister. The Yang di-Pertuan Agong shall act on advice to determine who is in his judgment, in His Majesty's judgment, that's likely to command the confidence of the majority members of the Parliament. So is the discretionary of the Agong, the discretionary of His Majesty without seeking advice or listening to the advice for anyone or any party. Secondly, the Yang di-Pertuan Agong has a discretionary power withholding consent to withhold consent for a request for dissolution of Parliament. Let's say Prime Minister wants to dissolve the Parliament, he has to request with the Yang di-Pertuan Agong, but the Yang di-Pertuan Agong may withhold the consent for dissolution of Parliament. And the third discretionary power is to call the Conference of Rulers for meeting. So whenever the Conference of Rulers is the Council of the Rulers combining or combination of all rulers in Malaysia, as you all know, we have 9 rulers and we have 4 Yang di-Pertuan Negeri who's appointed by the Yang di-Pertuan Agong. Occasionally, the Yang di-Pertuan Negeri also part of the Conference of Rulers. But as far as the Conference of Rulers discussing on matters regarding the position of the Raja, the privilege of the Raja, the privilege of the rulers, the Yang di-Pertuan Negeri are not members of the Conference of Rulers. The point I want to make here is that if the Yang di-Pertuan Agong or any members of the rulers wants to have a Conference of Rulers meeting affecting the position, powers, honors and dignities, and is the discretion of the Agong. Yeah, these are the 3 items. If people say that the prerogative belongs to the Yang di-Pertuan Agong and the Yang di-Pertuan Agong may not act on the advice, or he shall have the full discretion of the decision to make. But another sentence that I've been always missing in the general discussion of the public is that the Article 40, Clause 2 of the Federal Constitution says that the Yang di-Pertuan Agong may also have discretionary power in any other than these 3 cases that have been mentioned. That it can be in the Constitution that the Agong also has some other powers, other matters that he can exercise or His Majesty can exercise according to his discretion. It's not only limited to the 3 matters or 3 items that I've explained above or I explained before under Article 40, Clause 2, paragraph A, B, and C. And the 4th one is not named in a paragraph, but is stated very clearly in Article 40, Clause 2, that the Yang di-Pertuan Agong also has some discretionary powers in any other case mentioned, in other cases mentioned in this Constitution. So these are the 4 items. How does it relate to the proclamation of emergency? So this is important. How do the discretionary powers of the Yang di-Pertuan Agong is related to the proclamation of emergency? We shall explore this in the next slides. Yeah, the Yang di-Pertuan Agong proclaims emergency, proclamation of emergency. So the relevant provision is under Article 150 of the Federal Constitution. Yeah, the Yang di-Pertuan Agong proclaims emergency if His Majesty is satisfied that there's a grave emergency. So the grave emergency, or there is an imminent danger on the occurrence of such event, the Yang di-Pertuan Agong also has the power to issue different proclamations at different places on different time. The Yang di-Pertuan Agong also has power to issue proclamation for the purpose of the whole federation. It can be part of the federation, it can be one small place in the federation, or it can be for the whole or throughout the federation. The questions that probably discussed among the public is whether the Yang di-Pertuan Agong Act advice or the Yang di-Pertuan Agong Act on discretion when His Majesty is to proclaim emergency. That is the main theme or the main discussion. Of course, it looks like the situation is still uncertain because there are some people argue that the Yang di-Pertuan Agong shall act on advice following the generality effect of Article 40 Clause 1 and also Article 40 Clause 1A. When Article 40 says that the Yang di-Pertuan Agong, in exercising his functions under the Constitution, he shall act on advice. When His Majesty is required to consult or to get opinion, or after consulting other people, then the Yang di-Pertuan Agong shall act on the advice. So people who say that the Yang di-Pertuan Agong in the proclamation of emergency shall act on advice because of the generality provision or the general effect of the provision Article 40 Clause 1 and also Article 40 Clause 1A. And another group of people say that it's a discretionary power of the Agong because Article 150 Clause 1 says that if the Yang di-Pertuan Agong is satisfied that there's grave emergency, the word satisfaction is not described. The word satisfaction may not describe that the Yang di-Pertuan Agong is satisfied upon receiving advice from anyone or from Jemaah Menteri. It's not stated in Article 150 Clause 1. So 150 Clause 1 says that if the Yang di-Pertuan Agong is satisfied, so how does the Yang di-Pertuan Agong gets the satisfaction? If he received the advice, is probably not to have his own satisfaction, but he's probably acts on the advice. So the uncertainty is that there are various agreements. Actually, I've written in my opinion a subject matter. I have a lot of reasons for people to say that it is based on the Agong acts on advice, or the Agong shall not have the duty to follow the advice. So if to look at Article 40 Clause, I know it's very technical, but the question that I want to answer is only whether the Agong have to receive advice from the Jemaah Menteri, or can the Agong by himself proclaim emergency. So many people have not addressed this in any other case mentioned in this constitution. So some people who say that it's a discretionary power says that in other case mentioned in the constitution, the word used is satisfaction. So when the word used is satisfaction, it's the Agong's personal satisfaction upon receiving information or data from other people, then the Agong satisfied that there's a grave emergency. So it's not necessarily act on the advice of the Prime Minister or the Jemaah Menteri. So I've answered one question, is what is the role the Yang di-Pertuan Agong proclaim emergency? Yes, the Agong will proclaim emergency when the Yang di-Pertuan Agong finds that there's grave emergency or there's an imminent danger of occurrence of such event, the event that caused grave emergency. So the Agong also may issue a different proclamation. There may be 3, 4, 5 proclamations at one time, and at the moment we have 4 proclamations of emergency, 3 for a specific area, Great Bugaya and also Batu Sapi, and we have another proclamation of emergency beginning 12th of January throughout the Federation. So this is what we have. I want to refer to what Dr. Nouri said at the beginning, that he has not experienced the state of emergency. Believe it or not, we've been living in the state of emergency since 1963, 1964. For the whole Federation, the most important is 1969. We've been living in the proclamation in the state of emergency since 1969, at least, because the proclamation of emergency in 1969 was only revoked in 2011. So Malaysia has been becoming a developing country within the states of emergency. So if the government is, if we say that the proclamation is emergency, we haven't experienced the proclamation of emergency, the answer is no. Because most of us now were born during the proclamation of emergency. And then we've been living, we've been studying, we've been pursuing until our Doctor of Philosophy. We learn is the state of emergency. I was born 1 year before 1969, and throughout my life until 2011, I've been living in a state of emergency. That's the real impact. That's the reality in Malaysia. Since proclamation of emergency in 1963, 1964, when we have confrontation with Indonesia, there's also the state of emergency. It had never been withdrawn or revoked until 2011. So that's it. All right. So now, if the Yang di-Pertuan coming back to act on the advice, if the Yang di-Pertuan Agong proclaims emergency, can anyone question this in court? The answer is no. Now, if the Yang di-Pertuan Agong is satisfied that there is a great emergency, the Agong satisfaction shall not be questioned in court, because Article 150 clause 8 says that there are two things that mentioned in Article 150 clause 8. One is that no one shall question the satisfaction of the Yang di-Pertuan Agong once he proclaims emergency. And secondly, any law passed by during the proclamation of emergency, if the Yang di-Pertuan Agong satisfied that it is necessary to have such law, the law cannot be questioned in court, or the ordinance, the law made during the proclamation of emergency or promulgated, as the legal jargon says, the law promulgated during the proclamation of emergency named ordinance. And that ordinance, the legality, constitutionality, or whatsoever manner, cannot be questioned in courts. This because Article 150 clause 8 was inserted into the Constitution in 1983. So
we have some last question.
Shall we entertain the question now, please? It's okay then. Do we have it in chat conversation, the meeting chat, or what?
Hello, Miss.
Yes.
My question is, for the proclamation of emergency, I take the example of right now, the darurat from the Agong statement. I want to know what's the criteria or maybe some situation that can be suggested to against that proclamation. For example, the Agong asked for launch the darurat on Malaysia. Yes, and Malaysia is now on darurat. So who the person or maybe a power that can ask Agong to not mention or to not launch the darurat?
To
against the proclamation of emergency.
To stop. To withdraw.
Yes.
Okay. If that is the case, if we look at article, thank you Iman, Azra, Khairul Nizam for the question. As I said, Article 150 clause 8 of the Federal Constitution says that no one can question on the satisfaction of the Yang di-Pertuan Agong. So if the Yang di-Pertuan Agong, shall I read? Okay, Iman, shall I read this from the Constitution? I hope you can have a copy of the Federal Constitution. Article 150 clause 8 says that notwithstanding anything in the Constitution, the satisfaction of the Yang di-Pertuan Agong mentioned in clause number 1 and clause number 2b shall be final and conclusive and shall not be challenged or called in question in any court on any ground. So it looks very obvious that but it's very obvious that the Yang di-Pertuan Agong satisfaction shall not be questioned in court by no one on any ground. So it's very obvious again in clause number 8, paragraph number B, which says that no court shall have jurisdiction to entertain or determine any application, question or proceeding in whatever form or in any ground regarding the validity of the proclamation of emergency. So it looks like Article 150 clause 8 is very obvious and very critical to say that there's no such no such rights given to anyone on the satisfaction of the Yang di-Pertuan Agong. Okay, so I think I've answered you, Iman. Please give me a response. So that's it. That's what we have now. Yeah, that's what we have in the federal constitution now. Okay, shall I move to the next slide? Because I have another 5 slides. Yeah, but what Agong can do during proclamation of emergency, there are 2 things. Yeah, thank you, Iman. So there are 2 things that regarding yang di-Pertuan Agong for the regarding, I mean, the position or the role the Yang di-Pertuan Agong for the purpose of emergency. There are 2 things. One, the Yang di-Pertuan Agong proclaim emergency. Proclaim means isytihar, ya, mengisytiharkan berlakunya keadaan darurat. Itu the proclamation of emergency on the ground that the Yang di-Pertuan Agong may proclaim emergency on the ground that there's a grave emergency exists, or before the occurrence of emergency, the actual situation has not happened, but the Agong is satisfied that there's possibility to happen. Then the Agong can proclaim emergency when there's a threat against security of the Federation, economic life, and the public order of the Federation. It had been decided that the economic life and the public order includes pandemic. So it had been decided in the case of Stephen Kalonikan that the word public order includes epidemic, and I've interpreted it epidemic. What more if we have pandemic? So there's possibility of proclamation of emergency. So the Yang di-Pertuan Agong may proclaim emergency, and at the time when the Yang di-Pertuan Agong proclaim emergency, when the country is under the state of emergency, if during that state of emergency both houses of parliament are not sitting concurrently, then the Agong is satisfied that circumstances exist which render His Majesty that necessary for His Majesty to take immediate action. He may promulgate such ordinances as circumstances appear to him require. So at the time, one, the Yang di-Pertuan Agong can proclaim emergency. Second, the Yang di-Pertuan Agong may promulgate ordinance or law made during the proclamation of emergency if the parliament are not in session. Both houses are not sitting concurrently. Concurrently, both houses are doing their own business at the same time. All right. If the Yang di-Pertuan Agong, if both houses of parliament are not sitting concurrently, the Yang di-Pertuan Agong may promulgate ordinances as the circumstances necessary for His Majesty to take immediate action. So the key word to control the mechanism to control the power of the Agong is to make sure that it's necessary for himself, for the Majesty, in His Majesty is satisfaction that is necessary, and circumstances require to him, circumstances appear to him to require such a law. So the problems, the mechanism to control the centralization of powers, people are questioning the power the Yang di-Pertuan Agong has caused death, democracy and all that. So there have been a debate in the public, I'm sure, people, we have been reading this on the media and social media regarding centralization of powers, but the Constitution provides for some mechanism to control the centralization of powers. It's mentioned in Article 150 Clause 3 that the proclamation of emergency itself, the pengisytiharan itu sendiri, and the law made during the proclamation of emergency shall be tabled before both houses of parliament. So this will be read, there will be questioned before the parliament that whatever had been done during the proclamation of emergency, unless it's sooner revoked. Yeah. And Article 150 Clause 3 also give powers to Parliament to annul any proclamation or ordinance. Boleh membatalkan. Parlimen boleh membatalkan apa juga proklamasi dan juga apa juga undang-undang yang dibuat semasa darurat. So the Parliament may annul the proclamation of emergency and any ordinances made during the state of emergency. There's another way to control the centralization of powers, Article 150 Clause 2B, 2B, which says that certain circumstances exist which render it necessary. So the Yang di-Pertuan Agong must satisfy that circumstances exist which render it necessary. It's not that out of the blues that the Yang di-Pertuan Agong wants to enact such law. So it must be proven that certain circumstances exist and that circumstances render it necessary for the Yang di-Pertuan Agong to proclaim such emergency and to make such ordinance. Once the proclamation of emergency was made, once the ordinance was made, and if the Parliament comes to session later on, all this will be tabled before the Parliament. So it's not something easy to make the law during the proclamation of emergency also. Okay, now let's go to, this is my final discussion, part of discussion on the case law. So far, what had been decided. I mean, I presented this slide yesterday together with Scarlet Law Journal, present a webinar. Also, I copied this from my previous slide. But what is meant by security of the Federation, economic life and public order of the Federation, but it's not defined by the law. It's not defined by the Constitution. It's open-ended. It's open-ended. It's a very wide definition. Wide definition can be given to all these three phrases. And Bhagat Singh, the Indian case way back in 1931, is a very old case. A state of emergency is something that does not permit of any exact definition. It connotes a state of matters calling for drastic action. So that is what we call emergency. That it needs drastic action. These are the keywords. Yeah, these are the keywords. Drastic action that immediately necessary at the circumstances requires. Yeah. So this Stephen Kalok-Ninkan talks about the scope of these matters, where, as I said earlier, that the threat or force of any manifestation, Article 1.
Prof, I think you have been muted.
Unmuted. Why is muted? So Article 150 allows the Yang di-Pertuan Agong to make law, although it's contrary to the Constitution. And as I said earlier, that the emergency can be made on the ground of epidemic. If you can see in the last sentence, the last words, epidemics and the collapse of civil government. In this situation, you can proclaim emergency. Okay, my second last slide to talk about the prerogative powers. Who has the prerogative? Who has to decide? What we discussed just now, the law that we discussed just now, then I'm now illustrating this using case law decision. In 1967, it cannot be argued that it says that the prerogative is equivalent to the British powers, the British sovereign powers, which says that to act on advice. But in Stephen Kalok-Ninkan 1968, Barack Obama President says that once the Majesty is satisfied that the grave emergency exists, it is not for the court to inquire as to whether or not he should have been satisfied. So this has been translated into the amendment of the Constitution, as I mentioned now in clause number 8. So the decision in Stephen Kalok-Ninkan in 1968 says that if the Yang di-Pertuan Agong is satisfied, that satisfaction shall not be inquired by the court. And the Agong is the sole judge to make a decision whether there should be a state of emergency or not. The decision made by Barack Obama President in 1968 was translated into the amendment of the Constitution by inserting clause number 8 into the Federal Constitution. Clause number 8 into Article 150 of the Federal Constitution. Well, so almost settled now whether the satisfaction of the Yang di-Pertuan Agong is questionable in court or can be brought to court on the ground of that satisfaction on. Yeah, so it seems like now there were differences of opinion where in Stephen Kalok-Ninkan 1967 it says that it's equivalent or is analogous to the British sovereign, where the position is that the Agong shall act on advice. Stephen Kalok-Ninkan says that no. In 1968, Stephen Kalok-Ninkan says No, the Yang di-Pertuan Agong is the sole judge of his satisfaction, and once His Majesty satisfied, it shall not be questioned in any court of law. So in 1979, the court in Teh Cheng Po, this is the Privy Council decision, is the highest court at that time, says that it has to be done in accordance with advice. So there have been fluctuations, there have been differences of opinion regarding the courts, regarding the powers of whether it's questionable in court or not. And it was, as far as the case law is concerned, it was decided in 79. But the amendment to the Constitution happened in 1980s. It's 1983. So the amendment to the Constitution is the latest one. So that is the law. So the law now states that clause number, sorry, not 1983, it's 1981. Yeah, clauses number 8 and clause number 8 and 9 were inserted by the constitutional amendment in 1981 by Act number A514 and section 15D with effect from the 15th of May 1981. So now, until then, we haven't yet to get a case law decision. But in my opinion, the law is almost settled that one cannot question the satisfaction of the Yang di-Pertuan Agong. But debate on whether the Agong acts on the advice or the Agong acts in his own discretion is yet to it is open for discussion, because it's not being decided by case law. But if you ask me as a law student, I would say that I would like to say that it's the satisfaction of the Yang di-Pertuan Agong not to act on. It's not necessarily that the Agong acts on advice, and my personal opinion that it is a prerogative power of the Yang di-Pertuan Agong. So I think this is my last slides. And who can revoke the emergency? Article 150 clause 3 says that if not sooner revoked, meaning one who proclaims emergency can revoke emergency. That is why the current emergency, the emergency at the moment is that it will end by 1st of August as proclaimed or as gazetted in the proclamation of emergency 2021. Yeah. So the one who proclaims can revoke, and therefore no formal instrument required. But under 150 clause 3 says that this Parliament may by way of resolution announce it. So either Parliament can revoke or the Agong also can revoke if Parliament not yet to session. I think that is all my presentation. I hope I can learn from questions and comment from the participants, and I would like to say that this is just my opinion and how I see things and interpretation of the Constitution based on my reading and also my analysis of some cases and so some materials and literature. Back to you, Mr. Chairman, Mr. Moderator, and I thank to all participants. Assalamualaikum warahmatullahi wabarakatuh.
Waalaikumsalam warahmatullahi ta'ala wabarakatuh. It seems that 30 minutes is not sufficient, Prof. I think maybe I'm hoping if you have some other questions from the audience. And I also like to request the audience if you can share the question early, and then we can actually try to, maybe some of you have the same question, so we can, do not have, we can arrange the questions so that all of the questions can be answered and responded by our guest speaker, inshallah. So thank you very much again, Prof. Datuk, Dr. Sham, for your sharing session. There are so many things that I've learned. Of course, you have corrected me about the the emergency state that has not been revoked and so on. And so you have shared about how the prerogative power that has been vested into our Yang di-Pertuan Agong, and how the proclamation of emergencies were done based on the satisfactions of the Yang di-Pertuan Agong, the Majesty, upon the advice from the Prime Minister. I think if you can remember in Malaysian case, this is the second time, or the first time. I think our Prime Minister has already met the Yang Tuan Agong and the request for what do you call that, the emergency state was not being consent. I think if I'm not mistaken. So again, this is how the dissatisfaction of the Tuan Agong was not being. It was not, he was not satisfied when it was first being submitted to him. So anyway, thank you very much, Prof. Datuk. I think we will wait for question and answer. We have another session with you, inshallah. So we will move on to our second speaker, yang bagi Dr. Anom Wahyu. This is very interesting because I think the first when we planned for this, we are talking about having only two speakers, but later on because this is something that we can learn from our neighboring countries. I mean, this pandemic is not just particularly in Malaysia and in other states. For example, in Indonesia, they have experienced this. They have proclaimed emergencies, I think, in March last year. So they have actually maybe what we can listen from that Dr. Anom is her experience from Indonesia's COVID-19 emergency law, how it was being implemented, maybe what is the differences between what has been implemented over there in Indonesia and what we in Malaysia can really learn and can really, take lessons from the experience that we being shared, inshallah, by Dr. Anom. So, Dr. Anom, up to you now. Thank you.
Okay, thank you. Assalamualaikum warahmatullahi wabarakatuh. Alhamdulillahirabbil alamin. Wassalatu wassalamu ala asrofil anbiya'i wal mursalin Sayyidina Muhammad wa ala alihi wa sahbihi ajma'in, amma ba'd. Good afternoon everyone. Allow me to introduce myself. I am Anom Wahyu Asmorojati from Faculty of Law, Ahmad Dahlan University, Yogyakarta, Indonesia. Today I'm going to share about emergency law for COVID-19 in Indonesia, how the regulation and how the implementation in Indonesia. Would you help me to share my PowerPoint, the moderator? Because, okay, detail of my presentation is emergency law for COVID-19 in Indonesia. This is about the regulation and how about the implementation right now. Okay, let me start by giving you an introduction. Indonesia is one of many countries. Indonesia is one of many countries that we know affected by COVID-19. The pandemic has influenced many life aspects such as health, education, economy, social and technology. And similarly, legal practices are also affected, leading to the need of appropriate emergency establishment. Based on the data obtained from the Indonesian COVID-19 task force, the virus has infected more than 1 million people with more than 900 recovery and 30,000 deaths. This is from covid19.go.id. And the next, based on the article number 22 of the 1945 Constitution in Indonesia, in complying emergency, the President has the right to issue a government regulation in a leave of law. The emergency condition due to the COVID-19 pandemic has changed the people's life, not only in health, but also in economy, social, technology, and especially on law. In legal practice, law enforcement accompanied by high awareness to break the chain of COVID-19 spread becomes great challenge in Indonesia. Well, let's move on to this chart. I will give you some current data of 4 February the years of 2021. we can see here that Indonesia is ranked first for the pandemic case in Southeast Asia. Yeah, Indonesia, China, USA, Indonesia, Philippines, Vietnam, Thailand, Myanmar, Malaysia, Cambodia, Laos, and Singapore. And then from this chart show coronavirus disease statistic daily new case from September until January, the years of 2021. We can see that more increase in Indonesia. Right now is in 14,000 daily news case from this month to daily new case. And then next, legal framework for pandemic COVID-19 in Indonesia. During an emergency, the effective legal instrument were the law number 6 of the years of 2018 on health quarantine, law number 4 of 1984 on infectious disease epidemic, and also law number 24 on the years of 2007 on disaster management. There is a 3 law number in Indonesia, but on 31 March 2020, the President has decided public health emergency condition with the issues of the presidential decree number 11 of 2020. And next, government regulation number 1 of 2020 on the national finance and financial system stability policy for handling coronavirus disease COVID-19, and in order to face threats that endanger the national economy and our financial system stability has been amended into laws number 2 of 2020. This is enactment of government regulation in law number 1 of 2020 on the national finance and financial system stability policy for handling coronavirus disease 2019, COVID-19, and order to face threat that endanger the national economy and financial system disability. And further, I think the government has issued the government regulation number 21 of 2020 on the large-scale social restriction. We call it PSBB. In Indonesia, we call it PSBB, a large-scale social restriction, PSBB. We call it PSBB in order to accelerate the handling of coronavirus disease, COVID-19. Let's move on to the next slide. Legal review. How about the legal review of COVID mitigation policy in Indonesia? Yes, we will discuss about this. Article 27, paragraph 2 of law number 2 of 2020 mentioned that the state official holding the authority of the budget shall be protected from criminal or civil law in they implement the duties based on a good will. And then Kondre mentioned that corruption during the pandemic has directly increased the fatality rate. This is the facts. And then the increasing numbers of cases and death to the COVID-19 has proven the inadequate regulation to manage the pandemic in Indonesia. Hence, it's necessary to revise the contents of the law number 2 of 2020. And the next is the non-transparent policies about the spread of COVID-19 to Indonesia, fearing the potential economic effect has delayed the management of the pandemic COVID-19. Next, Presiden Republik Indonesia Joko Widodo, the Indonesian President, used his constitutional rights to issue the government regulation in emergency law, to enact a series of policy for financial matter, which indeed contradicts the 1945 Constitution in terms of state budget. We call it APBN, Anggaran Pendapatan dan Belanja Negara. In Indonesia, we call it APBN. Acts immunity rights to the financial officials and abandoned various law. And then in normal condition, we can say that in the normal condition, laws have not been implemented so as expected. It's getting more difficult to implement the laws as well as determining the sanction for those who violate them. Next, I will share about how the implementation of COVID-19 mitigation policy in Indonesia. People are found violate to COVID-19 health protocols. The first, maybe you can see from my slide, the first, in particular officials, holidays, especially during collective leave in November 2020, the tourist destinations are still visited by people outside the area. And this is the first. And second, COVID-19 spread has added new clusters such as office, family, religion. In Indonesia, it's very famous ya, cluster perkantoran. We call it cluster perkantoran, cluster keluarga, dan cluster keagamaan ya. There is 3 new cluster has added a new cluster for COVID-19 such as office, family, and religion. And the third, non-transparent information provided by the Indonesian government when the pandemic began has led to public distrust toward the policies intended to handle the situation. Non-transparent information from the government to our society in the earlier pandemic, maybe on February or Maret 2020 ya. The first time COVID-19 in Indonesia is 15 March 2020. And then fourth, law obedience to the health protocol is influenced by the public trust to the government. Yeah. And then fifth, slow management of the pandemic has decreased the government good impression. Yes, there is 5 implementation. And then the next slide, I will share. Previous studies found that the mitigation policies for the COVID-19 pandemic in Indonesia were corrupted. This is for Mario Arturo, the article of Mario Arturo. Hence, the use of state financial budget for the management has the potential of being corrupted by the official. Yes, this is the facts. It's contradictory to the public condition, which is economically affected by the pandemic. And the next, in the beginning, Indonesia government was less transparent in informing the COVID-19. In the beginning of COVID-19 pandemic, I mean, Indonesia government was less transparent in informing the COVID-19 spread because they are worried about its effect on the economic condition. Until 8 February 2020, the virus spread shows significant increase, reaching more than 8,000 new confirmed cases. And then the increase has added to the total number of the positive case into 1,160,079. It's very large. And then the highest spread occurs in Jakarta, which reached more than 3,000 new cases, followed by West Java with 1,500, and then Central Java, and then East Java and Yogyakarta, where I live right now. Yeah, Universitas Ahmad Dahlan is in Yogyakarta, special region of Yogyakarta. Other areas reporting new cases are Bali with 260 cases, and South Sulawesi 136 cases. In shortly, daily reports of COVID-19 spread has not shown any sign of decreasing, but increasing, of course, not decreasing, but increasing. In conclusion, let me sum up the main point of my presentation today. This is my point for today. The first, law number 2 of 2020 can only cover the effect instead of the cause, which is the pandemic. Yeah. We call it hanya bisa tidak pada pandeminya, tapi hanya dampaknya saja, the effect instead of the cause, which is the pandemic. And second, the legal material as the instrument for the government are adequate. It applies to all countries. What differs them are the options for the political and economic aspect, as well as the readiness and the term of health. But in general, not all countries are there emergency authority. And the third of my conclusion, Indonesia don't employ the emergency authority. Instead, it uses emergency law while optimizing the available legal instrument. When I mentioned the law number 6 in the years of 2018. Yeah? And the fourth, high fatality rate in Indonesia shows that the transparency, legitimation, and assertiveness of the government are the key factors of pandemic COVID-19 management in Indonesia. Okay, that's all for me. Thank you very much for this presentation. Wassalamualaikum warahmatullahi wabarakatuh.
Waalaikumsalam warahmatullahi ta'ala wabarakatuh. We have a question from Mr. Azami bin Ahmad. But again, Dr. Anom, if you may want to see the questions, I think I will leave this question for you to look into it, and then we have the next session. Then we try to manage during that question and answer during that. Thank you, Azami, for your questions. This is our member, our colleague from HTCC. Thank you very much, Dr. Anom, for your presentation, your experience, and also your sharing session of what has been the measurement and also the implementation of emergency act in Indonesia in order to curb down and to respond to the pandemic situations in Indonesia. So the last sessions is to our colleague from UTP. We are being blessed today to have Nur Arfah to be with us, to present with us some important aspect of the state of emergency in Malaysia in terms of what is our role, what is our right, and what should we do. So how will we Malaysian should deal with these emergency states? What is it that being protected by law? So there are so many questions of the right and duties of citizens, of Malaysians, of UTPians during the emergency states in Malaysia. So this will be responded by Mrs. Arfah. So I would like to invite Mr. Arfah to share her presentation. Silakan Arfah.
Okay, Assalamualaikum warahmatullahi wabarakatuh, and a very good afternoon to all. And this is actually an good opportunity for me actually to learn from the expert here. We have the Anom, especially, and Prof here, and also the audience, yeah. Because when we for this session, I will take the opportunity to share about the right and duties, yeah. But somehow that will be the discussion somehow will be directly connected with the discussion that been presented by Prof at the earlier session and also by Dr. Anom just now. And why this topic, it is a very significant for all of us to discuss, yeah? Because me in my class with my students, somehow I always give emphasis on this, yeah? Because right now as an individual, as personal, as an individual, we know our rights ataupun we want to preserve our right. And we believe that right is very important because right will give us authorization doing things, yeah? And when we want to talk about right, we need to know what authorized that right. Okay, so we will discuss that in this discussion. At the same time, what comes along with the rights? Okay, what comes along with the rights? Because this kind of awareness is very important because as an individual, we are not live alone. We live with people. So in a country, in a state, yeah, in a community, yeah, every person will have different preferences, yeah, and how we want to deal with these kind of different preferences. The needs of regulations is there. Okay, this is actually a very light discussion. I hope that dia boleh memberi keringanan sikit, ya, sebab tadi kita dah discuss quite heavy discussion. And first, I've start the discussion is actually to give a very general, because this is targeting the public, what we understand about the rights. And when we talk about rights, we have declarations, international declarations of human rights. We also have protected rights in the countries. Sovereign country will provide specific right, will give specific rights to the peoples. Why? Why we need this? This will give us protections to do things. For example, when we talk about right, it is known as a basic human freedom that protected by law. So the connections of the rights yang kita kata hak kita, saya ada hak buat ni, saya ada hak bersuara, kan? Okay, hak itu dapatnya daripada mana? Hak itu where? That kind of right will be authorized. That kind of right will be authorized by the sovereignty, by certain jurisdictions. When we talk about for example, in Malaysia, for example, we will talk about does that kind of right authorized by the Malaysian regulations, and what is the regulations, and what kind of rights protected, what kind of right, what kind of rights given to the peoples. Okay, and that is why it followed with the second term stating that the rights are legal. Means that, okay, when we state that, when we talk about right is legal, means that if there is a breach, for example, someone trespass ataupun someone breach that right, and you are the person who suffered out of that breach. So what you can do? This is the aims of law. The law will give you protections. The law will give you rights to request for maybe damages out of that, maybe to request for justice. Okay? Because the aims of law that we have right now, because today's session is about law, and maybe majority of our audience not in the background of law. So the key point usually when I teach law, when I discuss about law, I would like to address that the importance, the importance of the law is actually to give justice, but that kind of justice will be subject to the interpretations according to the jurisdiction. Then the next slide, yeah, is actually somehow I would like to address to all of us what can we understand about duties. Yeah? Russell Kick is one of the political analysts, apa nama, especially somehow like the political analysis something in US. He said clearly that every right is married to duty. Every freedom owes correspondent responsibility. Macam kita lah bila ada dalam kontrak kahwinan, okay, kenapa perkahwinan, why marriage is known as contract? Because with that agreement, with that ijab and qabul comes with the rights and duties. So duties is actually moral obligations of all citizens as prescribed by law. So ada tak duty? Is there any duties which is not prescribed by law? Yeah, could be. But that duty will not be enforced by law. And if someone want to enforce something which is not prescribed by law, that could be lead to illegality. So dia akan jadi satu kesalahan. Okay, duties are responsibility or obligations of an individual by the governing bodies that require to be done by the said individuals. Macam banyak saya sebut dalam I also teach in UTP. I teach hubungan etnik. That's one of my favorite subject. Yeah. We discuss right now we are in the week 6. We discuss about the topic of pemufakatan politics. Yeah. Last week we discussed about the constitutions as tiang seri hubungan etnik. So when we discuss about this, there are lots of rising issues that somehow concerns about the rights of the peoples in Malaysia, but at the same time somehow there are certain regulation maybe give certain privileges to certain groups. How does this will give justice to the group which is not stated in the constitutions? That is why when we understand this matter, yeah, when we understand about first about what is right, what is duty, and who authorized that right, not only up until that, we also need to understand the philosophy of such regulations, the reason why we have such kind of regulations. Although somehow we disagree, but in that meantime, until the law yet to be repealed or to be amended, the duty of us, we have duty to respect the regulations. Okay. Citizen, yeah, somehow citizen is citizen, vice versa non-citizens. So when we talk in the context of our discussion, this is we are discussing about the peoples of the state. In Malaysia, the proclamations of emergency is only for the Malaysians. For the Malaysian, it does not cover other jurisdictions. So Malaysians subject to the regulation. Subject to that jurisdictions, subject to the regulation which gazetted in that particular jurisdictions. Therefore, we as citizens will have different rights ataupun different authorized right compared to non-citizen. But does that mean that non-citizen will be marginalized ataupun will be discriminated? No, because we have other things somehow. That's why we have the discussion ataupun we have the movement of international human rights. We have the declarations of human rights because this is actually one of the mechanism that being advocates in order for the governments, because the government has duty to govern the state. The government need to have authorization, but the possibility, the probability of the abuse is there, because some concern about what about the rights of the minorities, what about the rights of certain groups, maybe not visible, maybe it is not known about something ataupun not really vocal enough. So how we want to deal with this? So non-citizen will have specific specific protected rights, but they will be different authorization ataupun different rights according to the jurisdictions. But the duty of the state definitely need to ensure that siapa yang ada di dalam negara tersebut, contohnya di Malaysia, will be protected. We've seen the example. Contohnya in COVID-19, how we try to deal with the COVID-19. I am very blessed somehow in Malaysia. although somehow there's issues, there's issue ataupun there's allegations stating that there are violations of human rights, with regard to the treatments of illegal immigrants, who came to the state. Remember pasal kita kata berita daripada, kenapa saya lupa, saya lupa. Ada controversial reports stating that Malaysia violates the human rights, with regard to the treatments of the illegal immigrants. Al Jazeera, thank you, tolong jawab Al Jazeera reports. So it's become an issue in the countries, because for on the part of the government, how they come to argue that is a part of their ways to deal and to ensure that these illegal immigrant, instead of they run away or just they hide because they're afraid they may subject to the law because they are illegals, these people need to be traced in order to ensure safety to the public in Malaysia. Therefore, Malaysian government take action to call them, stating, and then when they're gathered, there's this illegal immigrant subject to regulation, and this is among the concern and among the rising issues. As for me, how I see this, we have proof to the world, regardless of the claim made, Malaysia is actually government of Malaysia is actually putting every effort to ensure the safety of whoever, either it is legally or illegal, they are all be treated to ensure the safety of the peoples. Yang ini pun juga antara yang saya share dengan Perak FM yang lepas bila kita bincang, when we discuss about the why Malaysian is different. It's not only Malaysians, I think most of Asian country, if we make comparison with US, US is having difficulties in enforcing the regulations regarding the COVID-19. Kita dapat tengok, we can see that the people's make objections. They also objection or the restriction of movement. They also make an objection wearing mask, because they claims that the rights to wear is actually personal rights. Okay, the right of movement is also personal rights. So this is part of the challenges that faced by other jurisdictions. But so far in Malaysia, I believe that the same goes to Indonesia and other states, Asian country. The difficulties in dealing with the public to adhere with the regulations is somehow a lot more easier. This is somehow kita patut syukuri lah, kan, because I believe it's not only we afraid of the government, but the people able to put the priorities. Priority means that what most important right now to be safe in the countries. Alright, continue. Okay, state of emergency, Prof already mentioned, but it is a very brief in the layman punya perspective. So bila kita cakap, when we talk about state of emergency, something yang comes to our mind as a layman ataupun public, apa benda state of emergency ni, what is the differences state of emergency and MCO. MCO pun sama, macam tak ada beza pun, there's nothing different. Okay, so ada bezanya, okay. Kalau if in the previous regulation, kalau previous regulation it is actually somehow banyak lagi panjang lah. Regulation we are referring to this one, Movement Control Order somehow, and also the Infectious Disease Act 1988, that's part of the authorizations of the law to regulate the publics, before the proclamations of emergency. Okay guys, kembali balik. Okay, ada Okay, so during emergency, macam Prof dah cakap tadi, so the government will have full authorizations, and the key is actually by the approval of Yang di-Pertuan Agong, and among the concern of the public is actually about the possibility of abuse of power. That's among the concerns. Like if we try to read the literature, if we try to highlight the concerns of among the certain group in the countries, somehow the reluctance, somehow they're afraid is with regard to the dysfunctions of the legislative institutions, the power of the government to make regulations, because this is the implications of the state of emergency. That is why I somehow my personal point of view, why DPA, Yang di-Pertuan Agong somehow can gain trust, and we can somehow, for me, I somehow rather trust in him in a way that he is not acting on whatever suggested by the Prime Minister, because the first suggestion is made in October to request for the emergency, but Yang di-Pertuan Agong play his role to examine and then to assess the circumstances and refuse to grant the proclamations of emergency in October. But then it comes again in January, as mentioned by Prof. But that situation, we all Malaysians also feel the same, feel the pressure. We need to do something, because why? Because the cases is spiking, and we are very worried about the safety of the people. And we can see that the Yang di-Pertuan Agong, considering all the matters, agree with the proclamation. So that is kind of one of our check and balance. That I can see that when we talk about, when we are already in the state of emergency, who is our check and balance with the current government? Our Yang di-Pertuan. What happened? Macam mana boleh credit? Kejap, give me some time. How is it?
You buat magic macam mana?
I don't know. Ended. Oh, ada orang ended presentation saya. Dia kata, please make it fast. Finish. I am very tired to hear this. Okay, no, again. Saya sambung balik sikit je. Saya akan concludekan dengan cepat. Jangan marah
siapa
saya.
Siapa yang buat tu? Okay, carry on. Proceed, Arfah. No problem.
Okay, jap. I upload again. Okay, saya tengok sampai mana tadi. Okay. That is why for the focus of our discussion is actually, tadi bahas intro je kan, how we want to deal with this. When the proclamations of darurat and also MCO previously, we are dealing with the mana the slide actually. We are, give me 5 minutes. The slide is missing.
Okay, no problem.
Okay, I share the window lah first. Tak boleh.
Okay.
Okay. This is somehow the discussion lah. Okay, that's why it's connected. Is actually sampai mana saya tadi? Right. Okay. We discuss about during emergency and darurat, and right now if people only talk about rights, not try to understand the duties, that could somehow be illustrated in these circumstances. Dia kata ni okay, sure glad the whole is in at our end, but at the same time if they doing nothing, they also may subject to kebahayaan itulah, boleh jadi lemas. That's why we need to understand the duties need to be together with the rights. Okay, this is the issue somehow, personal right versus public rights. When the regulations is there, we are not free to move, we are not able to work. There are certain regulation with regard to the business, for example. How we want to deal with this? Under the international covenants of the economic, social and cultural, this international law, which most countries have adopted, everyone has right to the highest attainable standards of physical and mental health. It is the duty of the government to take effective steps for the prevention, treatment and control of epidemic, endemic, occupational and other diseases. The challenge is that many of the most grave, the systematic human rights, somehow, as I mentioned just now, the concern of how we want to deal if there is abuse of power, the regulation, maybe the power when the government have right to regulate the regulation, would that take opportunity to stay in power, would they take opportunity to to regulate laws that could give injustice to others. So this is actually the concerns. And fundamental liberties, when we talk about rights in Malaysia, this is the authorization in our federal constitutions. We are referring to part 2. This is the right. One of the example that I highlighted here, you can see right, for example, prohibitions of banishment and freedom of movement. According to Article 9, and that's why we need to understand the law. Okay, every citizen has right to move, subject to, however, subsection 2, article 9, subsection 2, subject to clause 3, to any law relating to the security of federations of any part thereof, public order, public health, or the punishments of the offender, every citizen has the right. This is the authorized right to move freely throughout the federations. In clause 3 stated that so long as in these circumstances and in this constitution, any other state is in a special position as compared with the states of Malaya, Parliament may by law impose restrictions as the state and other state on the rights conferred in clause 2 in respect of movement and residence. So what I would like to address here is not the authorization for emergency, but the law. Usually you can check other regulations. For example, when we talk about Article 11, freedom of religions in Malaysia, although everybody has right to have freedoms of religion, but subject to clause 4 to with regard to propagation, there are certain limitation for propagation, especially to Muslim. So when we read the law, that is why when we understand about our rights ataupun when we understand about international right, we need to align with the provided rights in the constitutions. And then when we understand that, whenever the government create a regulations, somehow it seems that clash with our personal right, instead of we directly make an opposition, we try to make understand first. Kita fahamkan dulu, is it true? Who authorized this? Okay, how we want to deal with this? Okay, this is part of the important things, to make known the regulations. Tahu dulu sebelum kita ni, supaya when you know, okay, when knowledge is empowered, knowledge will empower you. When you already knew about the thing, because the law seek interpretation from the courts. As long as it's yet to, there is no definite interpretation from the court ataupun from the law, okay, that kind of interpretation might be pursued. You can pursue that interpretations, and then the court will become the final decision to decide whether your claim or whether your request can be included and can be recognized by law. That's how the law works. Okay, this is I mentioned about this during MCO. This is among the difficulties here, and United States. Yang ni saya mention also earlier in earlier discussion just now. US is among the country yang kita lihat very difficult. Susahnya lah kalau if I in US. It's very difficult. The frontliners there somehow having a very difficult times, because they didn't have full support like we have in Malaysia, Okay, because people questions, and then they have to deal with the patients. You see, in the United States, the rights of states to pass and regulate quarantine law has also been recognized by the judiciary at the national and state levels. This is one of the case. In the case of Rafrod Co against Hussein, US Supreme Court recognized the right of the state. This is actually give authorization to the state, although there is a rights of personal right, but the state has right to pass sanitary law for the protections of life, liberty, health, or property within its limits, law to prevent person, animal, and the rest. Another case it is decided in the case in the Court of Appeal in California, stated that in US, the adoptions of measure for protections of public health is a valid exercise of the police power of the state, as which the legislature is necessarily vested with large discretion, not only in determining what are contagious and infectious disease, but also in adapting means for preventing their spreads. So this is part of the court decision, somehow give authorization for the state to give limitation to the personal rights of individuals. All right. How I would like to address this. Maybe this is part of the thing that I said that all the other opinion, because somehow when we have the law of emergency, is that there is no hope. Okay, for example, this is what the school yang somehow have the concern about the possibility of the abuse of power, how to prevent abuse of power. Some of the arguments stated, some of the argument that still can be the justice still can be there, for example, in the circumstances, not Malaysia, other states, somehow tend to abuse the emergency and to create certain regulation that jeopardize ataupun that undermine the rights of the peoples. And how we want to deal with this, at the end, whenever the proclamations end, the people may question the regulations. That is somehow part of the argument highlighted by Gopal Sriram. Dia kata when they said that when people concerned about whether the emergency proclaim on January 12th can be considered as infringement to fundamental rights, and the Gopal Sriram, he is the retired federal judge. He said that ordinance promulgated under emergency can be challenged in court if it breached the fundamental liberties. But I believe that this is not easy in a way that during the emergency it can be cancelled. But later, for example, by the end of the proclamations of emergency, that regulation can be tested by law. That the justice can be sought. However, dia kata, added by Gopal Sriram, that the emergency proclamation is constitutional as it comes within the four corners of Article 150. It can be challenged if anyone had cogent evidence that declaration was done. This is the keyword, bad faith. Okay. One of the argument, one of the reference made by Gopal Sriram is actually case Municipal Council of Sydney against Campbell. It's not Malaysian case, but one of the reference, because we didn't have specific case yet. In that case, the local authority was empowered to acquire land for public purpose. What happened in that declaration of emergency? But it acquired land is actually to build a land bank. Okay, therefore, the court decided later when it is contested, the court decided that this is considered under improper use and also can be subject to bad faith. Another thing, how we want somehow when we talk about the rights, the personal rights and the public rights in the emergency, I believe that among measures also highlighted is with regard to the appointment of independent special committees. This is actually the independent special committee had been announced yesterday. Consisted of 90 appointed members from various backgrounds. So Section 2 of the ordinance emergency stated that the establishments of independent special committee to advise YDPA on the continuing existence of emergency arising from the COVID-19. The members will be appointed by the YDPA, and we can see from the list, the health expert, related expert, will be among the members. Oppositions member also one appointed in this committee. So this is one of the mechanism, and the last and the most important is actually the Yang di-Pertuan Agong staff, will be the one who will observe and also to ensure that whatever happened during this emergency is actually for the benefit of the public. I think that's all for my presentation. Thank you very much. I return back the session to Dr. Nuri.
Okay, thank you very much, Arfah, for the very interesting presentations of the topic. So I think we have concluded the three speakers, the three presentations, the three perspectives of the speakers on the topic on emergencies and COVID-19. I think it's very enlightened discussions and presentations by all the speakers. So we have a few questions here, the written questions in the meeting chat. So if I may want to start, I think the first question is to Dr. Anom, is from our colleague Mr. Azimi. If you can respond to the question, Doctor. I think everybody can read the question, okay? Okay, thank you very much, Doctor. You have another question, Doctor. If you can look down there from Muhammad Zahin, one of our students. He has a second question to you. It's about the logistic and also the restrictions in doing the emergency state in Indonesia. Okay.
Okay. Okay. Thank you for your question, Azimi. Azimi. Thank you for your good question. Your question is, does the legal fine or monetary compound the Indonesia resident may help to curb the COVID-19 virus transmission? And then, are your governments more on awareness to public rather than punishment strictness? The first, the fines imposed don't really curb the spread of COVID-19 in Indonesia, because actually in the reality, there have been many violations in the implementation of health protocols. Yeah? And then public awareness and strict laws are put important in preventing COVID-19 in Indonesia. Public awareness in obeying health protocol and also must obey the rules. I think that's all for me to answer your question, Azimi. Azimi is still in our meeting, is in our...
Yeah, Doctor. Thank you for your feedback. Appreciate it.
Both of public awareness and strict laws are both important, to strict law, And I think the fines imposed don't really curb, because actually in the reality there have been so many violations in the implementation of health protocol in Indonesia.
Yeah, same goes to Malaysia, Doctor. Welcome.
Same with the Malaysia?
Yeah, same.
Okay, I think that's all for me, Mr. Nuri, maybe.
You have another question, Doctor Muhammad Zahin. If you look back down there, Zahin have two questions. The first question is to Prof. Datuk. The second is to you. Based on my reading, the Indonesian government did not impose a strict movement control policy because of the geographical restriction. So, how do you respond to that? Can you see the question, Doctor?
Wait. I will search the questions before I answer. That's based on my reading, the Indonesian government didn't impose a strict movement control policy all over Indonesia due to Indonesia geography restriction. Help for people who are affected by a restriction. Assuming there is no corruption issue in the government, based on your opinion, is enforcing a strict movement control policy is still not preferable in Indonesia during the geography restriction? Okay, maybe
Yeah, Doctor.
Yeah, I need time to answer this question.
Okay. If I will get back to you later on. So can we move on to the Prof. Datuk? Prof. Datuk, are you with us? We have a question from Zahin, dedicated to you on the questions whether to some policy that are not being, assume situation where during the emergency period, the Jemaah Menteri enforced policy, which is the policy, and obviously will make the current pandemic situation getting worse. So, what is actually the possible response to this situation?
Okay, thank you for the question. Thank you Muhammad Zahin for the question. Yeah, if we look at the ordinance, emergency ordinance, ordinance darurat kuasa-kuasa perlu, it stated that the executive or the Jemaah Menteri or the current government still working as it is, However, as legally speaking, the ultimate power during the proclamation of emergency in making the law will be the Yang di-Pertuan Agong. So, in my opinion, since there's no such previous cases or previous decision, therefore it's just a matter of interpretation. In my opinion, at the time of the proclamation of emergency, during the state of proclamation of emergency, the ultimate power, the power belongs to the Yang di-Pertuan Agong. So the Yang di-Pertuan Agong, in my opinion, may possibly stop the government from making a policy which may cause spread to the pandemic, or may cause spread of pandemic COVID-19. Therefore, legally speaking, the ultimate power belongs to the Yang di-Pertuan Agong. Therefore, it will be possible for the Yang di-Pertuan Agong to stop the government from doing or from making a policy which will encourage or will spread pandemic. However, people may ask whether the Yang di-Pertuan Agong shall act advice or not during the proclamation of emergency. My proposal, my analysis, my understanding is that no, the Yang di-Pertuan Agong has his own powers of His Majesty to act according to advice of the committee that we have been established, which was pronounced in the yesterday. So I think that's my opinion. Thank you. Thank you again.
Thank you very much. I think that's clear. Okay, thank you, Ahmad. I think that we answer your question, Zahin. Okay, we have two questions for Puan Arfah. We have question from Ku Nora Shikin ni, student lama UiTP. Lama tak dengar kita.
Prof.
Dia lecturer. Kalau dengar suara pun bagus juga ni. All alumni lah. Okay, so one question from Ku, another question from Zahin. Okay.
Okay, thank you for the question. Kukin is actually my colleague ni, kawan baik saya walaupun student tapi dah gang kan. Okay, thank you for the question. Referring to the special rights given to the political elite, is it lawful? Okay, I know this is concerned about the recent regulations. So in dealing with this, with regard to the right now the regulation posed by the government is legal because they has right to that they have right to regulate that regulations. There must be reasons, there must be circumstances, and I believe also those who disagree also concerned about the safety of the public. Yeah? Therefore, the application will be the same as I mentioned in my presentations. Yeah? We need to prove the elements of bad faith in that kind of regulations. So it is not somehow easy for us to request for the cancellations because of the currently we are in the emergency. It's different MCO. The way how the regulations is made, we still are using the normal procedures. Yeah? But during emergency, the way the regulations is made is actually given authorizations for the government, which they believe right now, if they believe that such regulations is important in order to improve the circumstances, that will be legally will be valid. The contest, yes, we can contest the regulations, but the contest of regulations, as I mentioned just now, will be need to prove with regard to the bad faith. So whether it is lawful, the regulation according to the law is actually lawful, because it is they have authorization to do so. Okay, the second question is actually referring to lawyers. Yes. Okay, this is actually the court is still in action. We can proceed with the procedure. You can also engage with lawyers in the sense that, but we have to follow SOP. I think there are certain regulation with regard to the procedures, but with regard to the proceedings still in progress. It's stated clearly in the guidelines that all the court matters will be proceed as usual. So Zahin, no problem. You still can get consultation. No need to meet face to face. You can also have a virtual consultation with your lawyers. So this is somehow my answer. If it is somehow not true ataupun something which need to be corrected, I stand corrected. I would like to also to hear from other point of views.
Okay, thank you very much, Arfah. I see someone raise her hand or maybe his hand before. Suddenly it's not there anymore. Ada seorang. Anybody want to ask question? And I would also like to call upon Dr. Maran. Dr. Maran personally text me say, can I ask question? Dr. Maran, are you here? Yeah, Dr. Maran. Say.
Thank you, Dr. Nuri. And
Yes.
first of all, I would like to express my heartfelt thanks to all the great speakers. We have Professor Dr. Shamrahayu, and we have Dr. Anom, and we have Puan Arfah. Thank you for the whole team. Thank you, Dr. Nuri. Quick one. My question goes to Professor Dr. Shamrahayu. Yeah, Prof. I hope Dr. Nuri.
She's listening.
I'm listening.
Yeah,
I'm
thank you.
listening.
Okay, I am referring to the. When Agong, going back to the proclamations of emergency, when Agong consented to the proclamations of emergency, and it was actually done sometime in January, and the date actually Agong consented to the period of emergency implementation until August 1st, 2021. That is the date, 1st August 2021. Prof, I have a question. We know that Agong's decision cannot be challenged. I think it is very much clearly stated, and I think Agong's intention was good because this was done in view of fighting back the exponential growth that we had of this COVID-19, and it is done in the interest of the country. Could you please enlighten us what was the rationale that the period of the implementation of this emergency was done until August the 1st? Was this done arbitrarily, or was there any, or is there any clause indicating that this is the minimum or maximum period, or just clarify to us whether Agong has any kind of power to decide arbitrarily based on certain incident. I believe this was done because of the COVID, but how sure are we that COVID cases will be exponentially growing until August? Or what is the rationale of fixing this date? First,
okay, thank you very much, Dr. Maran.
Thank you, Prof. Thank you, Dr. Nuri. Thanks.
Yes, my friend, thank you. Yes, Prof.
Thank you for the question. A few things here that I have to explain myself. One is about, because I'm not involved in the process of making the decision whether we should proclaim emergency or not. Therefore, a rationale that had been presented by the Jemaah Menteri to the Yang di-Pertuan Agong, I have no access to the data, or no access to the materials or literature, whatever report that have been presented to the Yang di-Pertuan Agong. But looking at the provision, looking at the provision of the Constitution, there's no specific period of time where we can have a limitation of time or certain duration that should be abided by the Yang di-Pertuan Agong when proclaiming emergency. So it can be open-ended. It may not be for a specific period of time or within certain frame of time. Therefore, if the Yang di-Pertuan Agong wants to, there should not be any date or any duration, specified duration for the proclamation of emergency. That is to say, my opinion is that if we look at the Constitution, the Agong may allow it or may proclaim it and announce it open-ended without certain duration specified. However, we look at, I look this thing as in positive manner, where I think it would be better for the government to have that certain period of time, but it doesn't forbid the Yang di-Pertuan Agong to shorten the period of proclamation of emergency. It can be shorter than the period, or it can be revoked earlier than the 1st of August. So it is provided in Section 2, has been also explained by Ms. Arfah just now. Section 2 of the Essential Powers Ordinance 2021 says that there shall be a committee, the Special Independent Committee, to advise the Agong whether the existence or the non-existence of the reason to continue with the proclamation of emergency, with the states of emergency. So it can end earlier. It can be revoked earlier than the 1st August. All right. But and another thing is, in my opinion, it will be better for the government to have that limitation or duration specified, because it will at least pressure the government that you have to work hard during this period of time. That the government has to work hard during the period of time, not buying time to expand or to extend it beyond any specific period of time. Yeah. So I'm not sure about the word used by our brother asked just now, that the word arbitrarily. I don't think it's done arbitrarily. I don't think it's done arbitrarily, because there must be a reason. We must remember also, on the part of the Yang di-Pertuan Agong, His Majesty must be able to defend for whatever he has done, or otherwise the reputation, the integrity, the credibility of the institution shall be questioned in the Parliament, because it will be debated in the Parliament. If not sooner revoked, then it will go to the Parliament. The Parliament will debate on the proclamation of emergency. Although you cannot question this in court, but it doesn't bar the Parliament from questioning whatever had been done when the proclamation of emergency is laid before two houses of Parliament. So I don't think that it should be done, or it had been done arbitrarily, because there may be some data that have been presented before the Yang di-Pertuan Agong, or there may be some explanation that have been given. Because to me, the word arbitrarily is a bit harsh against the decision of the Yang di-Pertuan Agong. So the satisfaction of the Yang di-Pertuan Agong cannot be arbitrarily, because in the practice, the Yang di-Pertuan Agong also consulted people who have knowledge about the COVID-19. But I have to express my opinion regarding the formation of the Special Independent Committee as prescribed by as established by Section 2 of the Essential Powers, that this committee will be a mechanism to check and balance on what have been done, or what will be done by the government and also by the Yang di-Pertuan Agong during that state of emergency within that prescribed period of time. I think that is all my opinion. Thank you.
Thank you very much. I think that the explanation is
Thank
very
you,
clear.
Prof. Thank you.
Thank you.
Prof. Okay, I have two written questions from Dr. Pisol and Dr. Subarna. So our participant, I guess, are very interested now in the discussion. But I would like to call upon this, I think, the student Nur Ainin Sophia. She has raised her hand before the written question being posed. So Nur Ainin Sophia, are you with us now? Nur Ainin, you still want to ask the question, or this ataupun tangan ni dia tersilap angkat? Okay, if we have not hear from Nur Ainin, so if that's the case, mungkin silap ni. So can we go to questions by Dr. Pisol? Dr. Pisol, our friend colleague from MH, from the department. I think this is for you, Doctor, Prof. Datuk. Clarification on Article 150, 150, Clause 6A and Clause 5.
Okay.
Could you respond to this? After this, we
Okay.
go to Dr. Anom for the question before.
Okay. Article 150 Clause 5 states clearly that any ordinances made during the proclamation of emergency may contravene the provision of the Constitution. That is to say, during the proclamation of emergency, the executive has a very wide power as far as making the law for the purpose of the such proclamation. So the proclamation now, what we have now is that as mentioned in a gazette it has been gazetted under the proclamation of emergency. It states that it's for the purpose of Article 150, for the purpose of fighting COVID-19. Therefore, Article 150 Clause 5 says that during that proclamation of emergency, law can be made if deemed necessary. If the Yang di-Pertuan Agong or by the Parliament, they can make law inconsistent with the Constitution. Right? But Clause 6A talks about some limitation on the powers of the Parliament. It doesn't mention the powers of the Yang di-Pertuan Agong. It just mentioned the power of the Parliament. We look at very carefully. 150 Clause 6 says that if the Parliament makes law during proclamation of emergency using Article 150 Clause 5, the Prime Minister can make law which is inconsistent with the Constitution. However, the power of the Parliament does not extend to the power of making law on hukum syara, not to make law on the hukum syara, not to make law on the adat resam Melayu, not to make law on anak negeri Sabah and Sarawak. So Parliament cannot make law on these matters because the matters remain a state matter. So the federal government can can extend its powers to the states, but not to be beyond these matters. And Parliament also cannot make law which is inconsistent with the Constitution on matters regarding religion, language, and also citizenship. So this is Article 150 Clause 6A. So although the Parliament can make law during the proclamation of emergency, the power is limited, where the Parliament cannot make law on matters regarding the hukum syara, adat resam, and also the law relating to native, matters relating to native, and the Parliament cannot make law which is inconsistent with the Constitution on matters of bahasa, on matters of religion and citizenship under Part 3 of the Federal Constitution. Thank you.
Thank you, Prof. Okay, we have another question for Dr. Subarna because it seems that Dr. Subarna does not mention to whom the question is, requested to answer the question. So I think I will give this question to Arfah. Okay, because I'm the moderator and the chairman of the session. So with the authority vested to me. So Arfah, we answer this question. Before that, can we listen to Dr. Anom first?
Yeah.
Back to the questions that being asked by our brother Zahin. Okay, Dr. Anom?
Okay. Thank you. I will try to answer Muhammad Zahin's question. The question is, assuming there is no corruption issues in the government, based on your opinion, enforcing a strict movement control policy is still not preferable in Indonesia. Indonesia geographic limitation as archipelagic state greatly affect government policies in implementing large-scale social restriction. We call it PSBB. I have already mentioned on my presentation, there is PSBB. We call it PSBB, pembatasan sosial berskala besar. Jadi kita memberlakukan large scale social restriction. Because in archipelagic state, the population mobility is very high, especially in Indonesia. That's very difficult to keep human from crowding because human are zone politikon. Maybe that's zone politikon, always crowding. And actually, the Indonesian government cannot implement that large-scale social restriction because large-scale social restriction will be effective if carried out simultaneously in all of region in Indonesia. But right now it's not simultaneously. It's just only in some of region in Indonesia. That's the limitation of the geographical limitation in Indonesia. I think that's all I can share to the question of Muhammad Zahin.
Okay, thank you very much, Dr. Anom, for your response. Okay, just to share with the audience, the session should end at 5. We still have for 20 minutes, and you still have time to ask questions. Whether you want to do it verbally or you want to post the questions in the meeting chat. So if not, then the session may end earlier lah. But again, it is quite unfortunate lah for us to end the session earlier. Bukan senang nak ada contohnya kedua to have this distinguished speakers with us. So it is good if we can make full use of the time and their presence in this webinar session. So can I have Puan Nur Arfah to respond to Dr. Subarna's question? Puan Arfah, unmute.
Thank you. Thank you for the question. Actually, the court is actually in process. Berjalan seperti biasa. Dan kalau kita tengok Malaysia, we embark e-hearings. For example, kita ada 23rd April 2020. This is the second time live broadcast court proceeding in the Court of Appeal. Dan maksudnya we started the MCO kita kata March, and then memang the court also comply with the SOP procedures. My friends also as lawyers, they having a hearing through online platform. So far, it is in practice right now. But I believe that there are certain mechanisms taken by the court in order to ensure with regard to the legitimacy of the evidence and whatnot. That's all. And we adopt that.
I think we have been shared in our group one video whereby in the court sessions there are some playing with the setting of the online communication, then appear the picture of a cat instead of the face of the panel. So again, this is where sometimes something is not getting as has been planned. Okay, again, I would like to open if anybody has any question. So we have questions. Our lawyer got okay, Dr. Anna, lawyers got stressed because of the face mask. Saya tak pernah share kat sini. If you could share it, something which is very interesting. Quite funny kan? How actually when you have your gadget being what do you call that? Played around with your kids, your children. Okay, is there any other questions? We're still open for questions. If you cerita kisah benar. Okay. Okay. If there is no questions, okay. If there is no question, I think what I want to do is that for us just to have for each speakers to have their closing remarks. For the conclusions of these sessions, I think there are a lot of issues being raised up by the audience, and I think for me, I think this session has enlightened me a lot and explained to me in the legal perspective of this state of emergencies in dealing with the pandemic of COVID-19. So for the closing sessions, I would like to call first our host lah. Puan Arfah dulu, boleh ke? Then we go daripada belakang ke depan balik. So we start with Puan Arfah. And then I will invite Dr. Anom, and the last, of course, Prof. Datuk, Sham, to end and give their conclusion remark of this session. Thank you, Arfah. Up to you now.
Thank you very much, Dr. Nuri, and also thank you very much for the audience. This is actually a great opportunity because sebenarnya dah lama saya tak berbincang sangat pasal law ni, ada tetapi very limited. Bila rasa ada jumpa kawan-kawan, when I met with the other friends, with the Dr. Anom and Prof together in a section, saya rasa semangat tu datang balik lah. So as a conclusion for the session, I do hope that when we discuss about this, what I would like to suggest to all of us to empower ourselves with knowledge. We can understand certain concern and certain issues might be raised, but somehow we also need to put trust, because in the difficult times right now, we have no one to we have no place to seek, because the government and the state is actually the authority who possess authority to ensure our safety. So whenever that somehow there are certain, I would like to encourage to all of us, in any ways we try to contribute to help this pandemic could be membaik, makin mengurang kesnya, insyaAllah kalau boleh habis awal emergency sebelum before end of August. And at the same time, we also need to become the agents to remind during these difficult circumstances to avoid something which could spark the chaos ataupun difficulties, because we have important matter that we need to deal right now, the safety of the publics. Okay, itu saja. Assalamualaikum.
Thank you very much. Waalaikumsalam, Puan Arfah. Just to share with all of the audience participants, actually, this is the session is this whole webinar is being planned by Arfah lah. Dia lah yang mula-mula cari orang, contact Prof Sham, Dr. Anom. So I think as the leader for the cluster governments and public policy, I appreciate her effort very much, and thank you very much for Arfah for organizing this event. So secondly, now I would like to invite Dr. Anom Wahyu for your closing remark and your reflection of this session. Dipersilakan. Ya.
Terima kasih. Thank you. According to our discussion for today, that's very great discussion. I think I have two main point for these topics. The first, Indonesia don't employ the emergency authority. Instead, uses emergency law while optimizing the available legal instrument. And then, actually, high fatality rate in Indonesia shows that the transparency, legitimation, and assertiveness of the government are the key factors of pandemic COVID-19 management. I think the three factor is the main problem of Indonesian government. And then to all the society, I think discipline of implementing health protocol is the most important. Yeah, maybe wear a mask, keep a distance, wash hands diligent, and so on. I think must obey the rules by the government. Okay, I think that's all for me, Mr. Amin. Yeah.
Yes, thank you. Yes, thank you. Yeah, Mr. Nuri boleh, Mr. Amin boleh, semua boleh. Dr. Anom, thank you very much for your participation. Ini datang jauh-jauh dari Yogyakarta bersama-sama dengan kita. So I'm very grateful for you to be with us today to share your experience, Indonesian experience, as well as we can see now the difference in handling the issues or the pandemic of COVID-19, different approaches. Of course, even the term may be similar, but the approaches and the implementations of the state of emergencies are different according to the need and also to the perspective and approaches of different states. I think we have learned a lot from you, Dr. Anom. Thank you very much for your contribution today. Hope to see you again, maybe later on, inshallah. We have another session with you. And last, and of course, save the best for the last lah. Kita ingin menjemput Prof Datuk kita, Dr. Sham, for her last word to these sessions.
Thank you, brother moderator, for giving me the opportunity giving me the opportunity to give my parting words. Yeah. First of all, I benefited a lot from the discussion and so much details that I've learned from Dr. Anom and also Ms. Arfah during the presentation. And also I learned a lot also from the question posted to me, as well as questions posted by the participants to all other panelists. That I have learned a lot from the session. First of all, we as Malaysian, we must understand the basic concept that introduced by the Constitution. We must not allow ourselves be emotionally associated with the understanding of perspective beyond what is allowed by the Constitution. As a student of law, students of constitutional law, it is my advice to all, and I call everyone to embrace provisions of the Constitution and be our way of life. Yeah, and I also address the issue of COVID-19 for us, as I don't have to say this. I know all of us are aware of all the standard operating procedure that have been introduced by the government. We must abide by it, but at the same time, we must always not forget. We must not forget that all this come from God, all this come from Allah, and that we have to submit ourselves to Allah. Apart from we do and practice or whatever SOPs that have been introduced by the government, let's do a lot of more prayers for us to be, for having this what we call pandemic, COVID-19. So it's not us that decide this. It's not us, but the one and only God which has decided this for us. And let us be safe. Let us be cautious of what's happening. And last but not least, I would like to thank the organizing committee, and I would like to thank particularly to Ms. Arfah for inviting me to be together. I would like also to congratulate Ms. Arfah for organizing this. And my special thank also to the cluster head, Associate Professor Dr. Shwarina, for giving such a great opportunity for me to be here. And thank you also to Dr. Nuri for moderating this seminar, and to Dr. Anom, salam kenal again. Moga silaturahim akan kekal dan berkekalan insya-Allah. To all participants, keep up the good works. Let us do together read the Constitution with the tagline merakyatkan perlembagaan. And with that, I end my presentation by lafaz wabillahi taufiq wal hidayah. Wassalamualaikum warahmatullahi wabarakatuh dan salam sejahtera.
Waalaikumsalam warahmatullahi taala. That's why I think I have do it correctly when I chose Prof Datuk to be the last one who concluded the session. I think that is a very interesting and meaningful conclusion. To wrap up the session, saya pun insaf sekejap dengan apa itu konklusi daripada Prof Datuk Dr. Shamrahayu as from UTP, from the Institute, ISB, and from CoSI and also GPP. I would like to again thank you and appreciate express our gratitude as Prof Datuk is willing to be with us today to share her knowledge, her experience, which is I think inspiring, which inspire us and to open our eyes and enlighten our views for this pandemic, and to see it clearly lah. So what is the need for us actually how we wanted to survive this emotionally, physically, and as well as spiritually. So may whatever happen and challenges that face us after this will make us stronger and greater, and to have more faith to Allah Subhanahu Wa Taala. Thank you very much all. all. I think this is a very great sessions. I'm really happy to be the moderator of this sessions, to be opportunity to be with you and to have this session together with all these great speakers. Okay, I think that's it. The for this sessions, and thank you again for all the participants, the students of UTP, those who are the followers of from Datuk Sham. We have those who are from Indonesia, the alumni of UTP, lecturers of UTP. Thank you all. I think I would like to finish or to end the session with Assalamualaikum warahmatullahi ta'ala wabarakatuh and good afternoon to all. Stay safe, stay blessed.
Waalaikumsalam.
Okay, thank you very much. Thank you, Prof.
Thank you.
Thank you, Datuk. Bye-bye.
Bye.
Thank you, Miss Arfah.
Ya, terima kasih. Nanti kita collaborate lagi, insyaAllah.
Prof Sham.
Nice. Bye. Bye, everyone.
We learn a lot from you. Thank you. Dr. Anom also.
Yes. Happy New Year to everyone who's celebrating the New Year.
Yeah,
You
that's
celebrate
right.
next year or celebrate Chinese New Year?
Yeah.
Alah, lupa nak sebut.
Thank you, everyone.
Yeah, selamat hari tahun baru Cina.
Cina. We have Dr. Chong Suli also join us here.
Terus boleh.
Yeah. My friend says it's not Chinese New Year. Let's celebrate next year.
Next year.
Thank you. Okay, bye. Shall I leave?
Okay, bye. Thank you.
Bye.
Yes.
Thank you, Prof.